a time of national security challenge and change. The list of challenges is a long one, as you well know. Here's a small sampling. Syria, Russia, cyberspace, Iran, North Korea, terrorism, pandemic disease, environmental degradation. There is change and transition as well, and not just in the American politics, but also in the shape of the law. There are also new and emerging tensions between security and privacy. And the environment in which government lawyers operate today, in which you operate today, is very different than it was even 10 years or 20 years ago in regards to the public's understanding of what you do or their lack of understanding about what you do and why you do it. All of this means that there is no more important field in the law today than national security law. Remember your mission. Remember your mission. National security law serves three purposes. It provides the substantive authority to act, as well as delimits that authority. It provides essential process, which is particularly important during times of transition and turnover. Justice Jackson said in Youngstown that in the government the tendency is strong to focus on the transient and immediate results of our actions and to lose sight of the enduring consequences to the Republic and to the Constitution. Good process incorporates the element of looking ahead at the enduring consequences of our actions. National security lawyers do that. The third element of national security law is values. National security values and legal values. One thing that unites America is its belief in the law and the rule of law. And by law, I do not mean a particular provision of law. I mean the higher ideals of the law, such as those reflected in the preamble to the Constitution and in the Bill of Rights, like justice, liberty, and providing for the common defense, predicated on shared responsibilities and freedoms. By law, I also mean democratic institutions. These are the values that are reflected in the beautiful and simple oath that civil servants and military members take to support and defend the Constitution.
Surgical, I do want to answer Jamie's first question, which is it authoritative? It is authoritative within the Department of Defense. It is not directive. So the DoD directive under which it was published says to ensure consistency in legal interpretation, the DoD Law of War Manual will serve as the authoritative statement of the law of war within the Department of Defense. Again, it's not directive, it's not prospective or aspirational, kind of getting out a number of the traits of the manual. It's more retrospective. It reflects DoD positions. It reflects a lot of U.S. positions.
If it's not directive, is a judge advocate in the field bound to follow it?
That's a little bit of a tough question. I would say that not bound in the sense of the general order. It's certainly not a general order. It's not directive in nature. It has a lot of academic aspects to it. So I think it would be really hard to determine exactly if it's being followed as such. It is authoritative, however, and I would say that judge advocate should be following the guidance that is found in the manual. If he or she has questions about it, should be looking into the sources. It's heavily footnoted, in part for that reason. Should be calling back through technical channels to the Chairman's legal office, service legal channels to explore further anything that they might have a question about. Because we have so much that we need to look into to deal with. It's hard. Not only was getting the manual out hard, but the first change that focused on the journalist section, or to follow on that, was hard to do, but we did it. So this is not a book that's going to be even 1 year on the shelf gathering dust and not changing, because within 1 year a substantive change was made. That section went from about 2 pages on journalists to 4.5, but with some, I think, really important substantive changes after working with the journalist community and
We're going to talk about that in just
quite
one
the
second.
process.
You've got the major caveats to the qualifying statements in the very introduction of the manual. Such statement says the manual's purpose is said to be that of providing information on the law of war. And then certainly while attorneys from the Departments of State and Justice participated in its drafting, the manual does not necessarily reflect the views of any other U.S. government department or agency, or even the views of the U.S. government as a whole. So, even more troubling to me is the fact that those expressions indicate to me that there were some serious disagreements amongst these U.S. government agencies with respect to what some of the fundamental principles of the law of armed conflict were. And to me, that's the most troubling aspect of it. Now, I've had calls from foreign colleagues saying, what the heck, Dave? I mean, is this the U.S. position on the law of armed conflict, or does it represent simply the DOD position, or perhaps not even completely the DOD position? So all these qualifying statements, I think, do diminish the credibility and the authoritative nature of it, and I think we have to accept that as a fact. Now, having said that, folks, it's the only thing on the street. And I think it does replace FM 2710 in 1956. It does have to represent the views of the United States at this point in time. So until we reach that point where we have an issue come up with respect to the law of armed conflict and publicly the various government agencies say we don't agree on that, I think we have to take this manual as the authoritative and definitive statement of the law of armed conflict.
Changes. A number of people have raised concerns about the distinction and proportionality provisions throughout the manual. So just to start with just the distinction aspects of it.
Can you give some examples, please?
Yeah, so, okay, well, proportionality might be a little bit easier, right? So, throughout the manual, there are sections that list people who would not count in a proportionality analysis. So, individuals who are working on, in, or around a military objective, for instance. So that factory workers, people who live near an Al-Qaeda safe house, for instance. And that includes people who may not know or may not voluntarily be there, or human shields, for instance, who may be involuntarily placed near a military objective, that those individuals do not need to be counted. Combined with a broad view of what counts as a military objective. So the manual includes war-sustaining activities that I think we might get into a little bit later. That's in section 5.9.3 as a military objective. So that means that if you have a civilian who is near something that is considered to be war-sustaining, that civilian does not count. And I'll read to you one of the passages it's in a footnote that many have flagged as very troubling, that says that in Vietnam, women and children placed mines and booby traps, that villagers of all ages and sexes willingly or under duress served as porters, built fortifications, or engaged in other acts helping the communist forces, and that it is well established that once civilians act as support personnel, they cease to be non-combatants and are subject to attack. And some people have interpreted this as saying that the manual would allow even children, so people of any age, people who are acting under duress, so involuntarily helping with war-sustaining efforts, a very broad term, are in that provision subject to direct attack. And then in other provisions where it says that they need not be counted in the proportionality analysis. So those sort of two, the war-sustaining and the proportionality analysis, when you put them together, you end up with a situation where civilians are not protected in the way that most of us think that the law of armed conflict actually protects them.
Why does it matter whether something is classified as a NIAC or an IAC?
Well,
In brief, because this is a complex
you know,
question.
international armed conflict defined in Common Article 3 is conflicts, all the cases of declared war or any other form of armed conflict between two or more of the highly contracting parties. International armed conflicts between states, recognized state entities. A non-international armed conflict traditionally was a conflict that occurred within a state in which a non-state armed group, as we now define that non-state armed group, is attempting to displace the constituted government of that state. My problem, Jamie, is that we have now gone far beyond that in defining what a non-international armed conflict is. Another provision in the manual that I have difficulty with, it says in some cases the term internal armed conflict is used as a synonym for non-international armed conflict. Such usage may reflect a traditional definition of non-international armed conflict as only those armed conflicts occurring within the borders of a single state. Non-international armed conflicts, however, are classified as such simply based on the status of the parties to the conflict. And I'll let you mull that over. And sometimes occur in more than one state. The mere fact that an armed conflict occurs in more than one state and thus may be characterized as internal in scope does not render it internal in character. Now, why does this definition of the NIAC and the manual's reference to transnational or global armed conflicts as not international armed conflicts occurring in more than one state? Why is that a problem? The question has arisen as to whether, depending on geographical circumstances or technical abilities, the spilling over of an existing non-international armed conflict is limited to neighboring countries. Now, I think that if you define non-international armed conflict in such a way, it's defined with one specific purpose in mind, and that's to support the U.S. contention occurring in the Bush and Obama administrations that we have been consistently engaged in an ongoing, global, yet non-international armed conflict with Al-Qaeda and its associated forces. And I think the definition of NIAC in the manual is used to support that ongoing contention on the part of the United States government, which far expands the definition of what constitutes a non-international armed conflict.
Well, I think that Dave is actually making a more important point than it matters whether it is an international versus a non-international armed conflict. Of course, he's right that it's, there's a broader set of rules that apply in an international armed conflict. But the point that he's making is not the difference between an IAC and a NIAC, which is, I'm sure, putting some people here to sleep, but between a situation that actually is not an armed conflict at all and a situation that becomes a non-international armed conflict. So the difference here, when you're talking about armed conflicts with groups like ISIS or Al-Qaeda, is between the ICRC position, which is that you look at a geographic area, you look at the territory of the state, and you look at the test for armed conflict with a non-state group and see if that test has been met in that location with respect to that group. So is that group organized enough to be engaged in an armed conflict? Are they using weapons of war? Are they directing military attacks? And has the violence crossed the thresholds so that it can no longer be said to be criminal activity that can be dealt with law enforcement, but that you actually see fighting that looks like armed combat going on? And that is when you trigger armed conflict rules, right? And there's a good reason for having that distinction, because up until that point, we want to apply law enforcement rules which are far more protective. And this goes to your question of why does it matter? It's like, well, because the law of armed conflict permits things that human rights law and law enforcement rules would be far stricter on, such as detention without charge or trial, and lethal force based on status.
Well, thanks for raising that. The cyber chapter was one where actually our boss bet that we would not be able to get a cyber chapter in there. So I'd like to, say, told you so to Steve and Preston that we were able to do it. Now, it was relatively short. It wasn't necessarily breaking any new ground. And I see that Charlie Dunlap is here. And very, very soon after the manual was published, Charlie blog, after looking at as an expert himself in this area, looked at the cyber chapter, perhaps looking for more than it had, but what he said was, he says, it breaks no new ground, it contains no earth-shattering legal propositions, but, quote, does a good job at gathering, organizing, and articulating views already on the record in DoD and elsewhere in the U.S. government. No doubt helpful to practitioners and scholars alike. And I just thought, he got exactly what the purpose of it is. And that chapter, some of those pages, many of the other pages of the manual are brought to teleconferences, they're brought to meetings by inter-agency council looking at issues just as where are we starting